somebody 20 years ago. But this matter made me extremely agitated, and I said, I will come back to you and defend someone. Not because of his status, because we can't allow a country to be degenerate to a situation where the criminal justice system now is used to harass opponents. That's all. We shouldn't do it. Context. Yes, I'll give the context.
Focus here, Mr. Njeri.
I'll give the context.
A minute, Mr. Njeri. The focus here is the accused, the law, the constitution. You understand our parameters, if you like. There are some parameters I am unable to swim in. I may not be very able to swim in. But I can swim in the constitution. I can swim in the law, I can swim. That's why I can swim in submissions around those lines.
The reason why I'm telling you that, Your Honor, so that I can go straight to the context,
Yes.
is that independent agencies will come here and pretend more often than not that they're doing their work independently. I'm telling you, as somebody who has been in those agencies, that unless as an individual you have the wherewithal to resist and do your work correctly, very few money to do that. That is the context. I'm not here to talk about where I was.
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matrix that the very learned senior is giving us are things that, with respect, he cannot tell us from the back. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts, so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that it's previously the commissioner, we understand. But let him get back to our case. Thank you.
To respond to that, look at the affidavit.
A minute, Mr. Njeri. I complete the recording.
You're gonna,
Mr. Njeri, your brief response, you are responding?
yes. If you look even at the affidavit, they've made general averments. To start with, problem number one, they serve us in an affidavit recently. What time do they expect us to respond to that affidavit? You know what is the trick? That it is designed in a manner that will expect us to make an application for adjournment so that we can file an affidavit. And in the meantime, the accused person continues languishing in custody. You know those tricks. Then the affidavit itself is marred with general averments. This is factual. They are talking about respondents agents. They are not naming which agents.
So just to be clear, you responding to the objection or you continue with your submission?
I'm responding to
That I'm
something
clear.
that he cannot say that I'm making general averments, yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he expects that I shouldn't be able to respond to that. But he's from the back. In the very least, that should be expected. He can't have a steak and eat it. In fact, we should be given more latitude because the subject of these proceedings is the accused. The rest of us are speaking here, and then we walk away. But is the subject. That is the person we should focus on.
Zero, give me time to give direction. Somebody wish to guide again, focus on your governance content. That is the issue of the table. Continue, Mr. Njeri.
Now, Your Honor, the accused person, somebody who has served this country for a long time, not just as a governor. Knowledge of who he is in the public domain, including very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. Besides being a governor, elected governor of a county. What was so difficult was just someone to court, telling me to appear in court in such and such a way. Why all the drama? Arresting the man and putting him in custody for this kind of charge. Why? It can only be for the sole purpose of punishing him. It can't be anything else. And it is that desire to continue punishing him that is driving the application for him to be denied freedom. You cannot allow yourself to be in realizing that objective. You can't. I have consistently seen the last line of defense for this country. The only one remaining, Your Honor, is the judiciary. And if judges, none whatsoever, let's not think that when you allow that trajectory, that everyone will be safe, including the prosecution itself. No one, I can tell you, Your Honor. We need to learn from history. So regardless of what happens here with these protracted submissions and responses and comments, Your Honor, I beg, do not fall under the trap of saying that you're going to write a ruling another day to be meted in this custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court, and he never appeared. Chesa, but I can tell you, Your Honor, this alleged misfunction that is being talked about, the accused was in Nairobi. Whatever is alleged to have happened was in Kitale. How do you start connecting him to something that is happening hundreds of miles away when he was in the office of EACC? How? So I'll allow my colleagues to say something, but I'll end by saying this. The reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Lawful use of the criminal justice system to intimidate and harass opponents. Your Honor, I once again plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you. Thank you, Your Honor. Briefly, just give the last aspect. Your Honor, just to associate myself with the submissions made by MILIMANI Senior, and to draw your attention to the content of the charge sheet, from where you will be able to drive the mischief. And the accused person is currently...
Slower. Pause after every sentence. The accused person.
It's not surprising that the accused person is charged before you with another person, Wafula Masungo, who is not before you. This is not by coincidence. It is not that Wafula's whereabouts is not known. It's because, Your Honor, the state was in a hurry to perpetrate this mischief. In normal circumstances, Your Honor, such proceedings do not have commenced. When we sought for explanation, Your Honor, MILIMANI Senior indicated that he was seeking summons. It's the same mischief, Your Honor. When we sought for clarification from the prosecution,
Slower.
the opposition, Your Honor, was that you will seek summons. And the nature of the summons was not. Indicated to you. That is to say, Your Honor, therefore the application for you to deny appeal must be read in light of that mischief. That other than pursuing public interests as dictated by Section 4 and 5 of the ODPP Act, the ODPP is equally pursuing other ulterior motives that are politically actuated.
And our apologies. Passing to the elections, to directed the focus on the charge sheet. If council has any
Minute.
person the elections,
Minute and recording is done.
the direction,
Minute, I'll give you the directions. Mr. Akula, you can continue.
the directed the focus on the charge sheet and the issues related to pay. The colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him to take the stand on the other side and we will give it to him. So let me speak on date. And that's about this person. We just not infuse any motive to anybody unless they are willing to take the law and bring it to the
Your response, Mr. Diego.
Your Honor, my response is contained in the affidavit filed by the ODPP. But it's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I was to proceed Your Honor, in response to the substantive application,
Minute. Must give direction and the objection. I remind that once more, I think belong to the law on bond and bill, to avoid instances which may persuade me to request the fact, evidence.
the affidavit contains mere speculations. There is no affirmation in the affidavit.
Minute, after every sentence, it have to change.
And there is no affirmation in the affidavit for you. The affirmations in the affidavits have no nexus with the charges before you. These are matters that are happening in other spaces, which none of us, neither the prosecution, nor the defense, nor the court, are privy to. That is to say, Your Honor, that to deny the accused person bail on account of presupposed investigations would be tantamount or will amount to violating his constitutional rights. And most importantly, the right to presumption of innocence and the right to liberty. The argument here The argument that the intended witnesses are subordinates to the governor, the accused person, again is not contained anywhere in the affidavit. And the same does not amount to a compelling reason. And so to say, the argument that vehicles were destroyed by his agents when there is clear lack of evidence linking the so-called agency with the accused person, again is speculative. Has no probative value of whatsoever nature. The same is not empirical, and there is no nexus between that affirmance with the affidavits and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more annoying is that the office of the ODPP, which is fully funded with the taxpayers' money, had no courtesy of proving the ownership of these vehicles. Your Honor, the producer of the so-called annexures, for instance, will not tell you who is the registered owner of KBU 734Y. Again, from the same annexure, you will not tell who is the registered owner of KCH 046T. It will not tell you who is the registered owner of KAE 7-8F. And you're being invited to deny bail on that ground. Registration of motor vehicles is a legal process. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, respectful to the process and the proceedings, and holding the values of the Constitution of accountability and transparency, they would have consulted the NTSA. Permit me just to, as a pen off, and invite my learned friends to draw your attention to the charge once again, that there is no charge that the government is facing that is linked to his office. There is no way in the charge sheet that says that the governor abused his office. There is no way in the charge sheet where there is a charge of conflict of interests. That is therefore to say, in the absence of such kind of a charge,
it has always been abused by those in power. It was abused during the colonial days. It was abused during the continental state. It was abused considerably during more, more state. The only president that can put in a word in his favor is my favor. Criminal law was not abused during that is
I think the statement is on the chart. The statement is home.
Oh, thank you very much, Your Honor. Now, Your Honor, permit me to go a little bit further. It is now being abused by the executive, by agents of the state. They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. And Your Honor, I'm urging you very respectfully that you can only get out of this quagmire with boldness from the petition. Our judges have to be bold. Our magistrates have to be bold and state very clearly that the country will not be governed the way it is being governed at the moment. Your Honor, we live in this country. Every day I'm reading the Sun, I'm reading the Nation, I'm reading the Star, and I go even further to read in other newspapers outside this country. Clearly, Your Honor, what is emerging at the moment, that unless we arrest the situation, nobody will have politics in the country. The country could easily be classified as a banana republic. I filed a case recently, Your Honor, in court, the usual course that we should refer certain matters now to the ICC.
Your Honor,
That we should refer certain matters of disappearances to the ICC. Let the International Criminal Court come in